Welcome to Custody Forms. This video will assist you in completing a parenting plan, a presentation of Legal Aid of West Virginia. In this video, we will go over how to fill out a proposed parenting plan. Watching this video does not mean representation by an attorney from Legal Aid of West Virginia. This video is for instructional purposes only. When completing your parenting plan, all parenting plans should be three things: reasonable, practical, and in the best interest of your child or children. If you find yourself having a hard time filling out this form, let those three things guide you in your decision making. This is page 1 of the parenting plan. At the top, you will write the county in which the case will be heard. This is usually the county that you and the child reside in. If a case has already been filed, write in the blank the county where the case was filed. If you are filing the case, you are the petitioner and will include your name here. And you will include the other parent's name here as the respondent. If the child's other parent has already filed the case, you are the respondent and they are the petitioner. If a case has already been filed, include the civil action number here. You can submit a joint parenting plan if both parties agree and include both names here. If you cannot reach an agreement, then you will mark the first box and note that this parenting plan is being individually submitted and include your name here. Then select whether you are the petitioner or the respondent. Remember, if the case has already been filed by the other parent, you are the respondent. Here you will select whether you wish the plan to be temporary, permanent, or both permanent and temporary. Now include your children's names and date of birth. Note that children subject to a parenting plan need to be children who are under the age of 18. If your child is 18 and still in school, you should also include them. If you believe the other parent should not have any parenting time, then you will select here and include your rationale here. This needs to be specific reasoning rather than something like, "I don't like the other child's parent." Reasons that a court may limit a parent's access to the children include domestic violence, or if the parent has abused or neglected the child. Listed here are other reasons that the court may require restrictions. If the child's other parent does not have conduct which requires parental restrictions, mark the first box, no restrictions. If you believe the child's parent does have conduct which requires parental restrictions, mark the second box. Then mark who the restriction should apply to. On page 2, you will list the reasons for the restrictions down here. This space must include conduct which requires parental restrictions, which you just reviewed on page 1 and 2. If a protective order is in effect, you should list information about the protective order. It can also include harmful conduct even if it is not listed. But again, this is not a space to say, "I don't like my child's father or mother." You need to be specific about the conduct that would cause restrictions on a parenting plan. If you believe there should be restrictions involved in your case, you will outline that information on page 3. If you believe someone should be denied visitation entirely, check here. Then check who should be denied visitation, whether it's the petitioner, the person who filed the action, the respondent, the other parent, or another individual. If another individual is involved, you should include their name here. If you believe visitation should be supervised, check here. Then select who should be the supervisor. You can propose any person that you trust, such as a professional, a counselor, psychologist, minister, or an agency or organization. You may also select a friend or family member of you or the other parent. Keep in mind the relationships between the person you suggest and the other parent. The purpose of the supervision is to protect the children and not make either party uncomfortable. Here you will include where the visitation should occur. This part will be completed for supervised transfers. Transfers refers to the time that you will pick up and deliver the children. If you believe that the transfer of the children from one parent to the other should be supervised, include a check here, and then fill in the box as to who should be the supervisor. Follow the same criteria in selecting your visitation supervisor when selecting your transfer supervisor, and make sure that the transfer supervisor has agreed to it. Oftentimes, people may use the same person if visitation is being supervised to supervise the transfer. Here you will include the location where the transfer should take place. Think of a point that may be midway. If there is domestic violence in your case, think of a location with a camera, such as a gas station or a police station. Finally, on page 3, list any other proposed restrictions you can think of. This may include things like no alcohol use or drug use, or not being allowed to drive with the child in the car. It can also include things like additional people that you think should not be around the children. In this space, be sure to be specific. Page 4 talks about major decision making as it relates to the children. As the page indicates, it is important to note 2 decision-making rules apply to all cases and all parenting plans. First, the parent with whom the child is with will make day-to-day decisions about the care and control of the child. This includes things like what the child wears, what the child eats, or when the child goes to bed. Second, either parent may make emergency decisions affecting the health or safety of the children at any time, regardless of who the children are with. Now let's look at the major decisions chart. Go through each subject and determine whether you want that major decision to be made by the petitioner, the respondent, or shared. Again, if you are filing a case, you are the petitioner. If the child's other parent has already filed, you are the respondent. There is a presumption that major decision-making will be shared between the parents. You will need to be prepared to explain to the judge why major decision-making should be yours alone. The court may grant sole decision-making to one parent for the same reasons that they place restrictions or limitations on that parent's parenting time. If you check the box for no visitation under the restrictions on page 3, then skip to the last page, page 15, and sign this page when you are in front of a notary. You are done. The remainder pages talk about how the time will be shared between the parents. Detailed and accurate proposals of the children's time and how it will be shared are very important. When a schedule for sharing the children's time is adopted by the court and made a part of the court order, that schedule will be the basis for the court's calculation of child support. For this reason, it is very important for the schedule to show the real number of days that the children spend with each parent. Page 5 applies to children who are not in school. If your children are in school, you will skip this page and move to page 6. If you have children who are in school and children who are not in school, you will include the children who are not in school here, and you will list the children who are in school on the top of page 6. This schedule relates to the petitioner. Again, the petitioner is the person who filed the action, and the respondent is the parent who did not file this action. Look closely at the dark black headings to make sure you are checking the right boxes based on whether you are the petitioner or the respondent. The first box is to decide what parenting time the petitioner will have on weekdays. The second box is to determine what time the petitioner will have on weekends. Mark the weekends of the month the children will be with the petitioner, all or part of the weekend, then fill in the time and the day blanks. The third box is to decide what parenting time the respondent will have on weekdays. Mark the day if the children will be with the respondent some or part of that day. Check all day if that applies, or fill in the times if the all day does not apply. The fourth box is to decide what parenting time the respondent will have on weekends. Mark the weekends of the month the children will reside with the respondent all or part of the weekend, then fill in the time and day blanks. A couple of other things to consider. Make sure the pickup and drop-off time is something you can do. If you get off of work at 5 and mark down the children will be picked up at 5, that is not reasonable. Be reasonable with what you and the child's other parent can do. Not every month will have a fifth weekend. If your goal is to do every other weekend, go ahead and check alternating. If you marked alternating in box 2, you should also mark alternating in box 4 and vice versa. Holidays will be addressed on page 7, so do not worry about them while creating a proposed schedule. Page 6 applies to children who are in school. You will include the names of the children who are in school here. If your child or children are school-aged or are anticipating them starting school soon, write their names in the blank. Remember, if you are the petitioner or the respondent. If you filed the case, you are the petitioner, and if the case was already filed, you are the respondent. Look closely at the dark headings to make sure you are checking the right boxes based on whether you are the petitioner or the respondent. The first box, you will list what parenting time the petitioner will have on weekdays. The second box, you will determine what parenting time the petitioner should have on weekends. The third box, you will determine what time the respondent should have on weekdays. And the fourth box is what time the respondent will have on weekends. Mark the day if the children will reside with the respondent some or all of that day, and check the all day if that applies. A couple of things to note. Make sure that the pickup and drop-off time is something that you can do. If you get off of work at 5 and mark down that the children will be picked up at 5, that is not reasonable. Be reasonable with what you and the child's other parent can do. Not every month will have a fifth weekend. If your goal is to do every other weekend, check the alternating weekends in box 2 and box 4. Holidays will be addressed on page 7, so do not worry about them while creating this proposed schedule. Page 7 looks at holidays. This chart lists certain recognized popular holidays and family occasions such as birthdays. It also provides spaces for you to write in other events or special family occasions, religious celebrations, or other cultural observations. For each occasion, in the columns even year and odd year, list P or R. P stands for petitioner and R stands for respondent. Even odd means that every other year the parent will have the holiday. Do not give one parent all of the even and the other all of the odd. This will mean that one parent will get every holiday for an entire year and the other parent will get nothing. Next, include the time that the parenting time will begin here. You may use the same pickup and drop-off time as your regular schedule, if that is applicable. If a child will spend part of the holiday with one parent and the other part with the other parent, indicate split day here. Then include what time the exchange will take place here. When you complete this chart, think about what your family has traditionally done. If, for example, the kids always spend Easter with mom's family, you should always give mom Easter. Another thing to keep in mind is how far apart you live. You can split days if you live closely, but that may not work if you live a long way away. Under other occasions, it talks about Petitioner's Day and Respondent's Day. These refer to what has traditionally been known as Mother's Day or Father's Day and recognizes that this may not be the case in your situation. If you have a very specific schedule in mind and you are unable to complete it on page 7, move forward to page 8. On page 8, you can outline any parenting plan you are proposing. This will work well if you are unable to do so on page 5, 6, and 7. Perhaps you want to increase parenting time little by little. For example, a few hours on Sunday for a month, then all day Sunday for a month, then an overnight, then increase until every other weekend. You can write that in this space in your proposed parenting plan. Perhaps you wish to alternate weeks and exchange the child every other week. That could be listed in this section as well. If you ran out of room on any of the prior pages and you wish to address additional family holidays, winter breaks, family reunions, you can write that information here as well. If you have nothing additional to add, you can leave this page blank. Page 9 covers summer and other vacation times. During the summer, you may change the schedule or keep the same schedule as during the school year. Some parents move to exchanging the children every other week. Some parents flip the normal schedule so that every other weekend is given to the other parent. The decision is yours. In addition to the regular schedule, you can add vacation times for each parent. You should decide how much time you would like for the children to spend with you and with the other parent. If you know your vacation schedule, you can add the dates here. If you do not know your schedule in advance, you should work together with the other parent to make arrangements for the specific dates and times of your vacation at least 1 month in advance of the time requested. Next, we move to the designation of legal custodian. Federal and state law require the parent with whom the children spend the majority of time to be designated as the children's legal custodian. This can have tax consequences. You should see a lawyer if you have questions. You may choose to alternate the legal custodian between even and odd years if you have an equal division of time. Check the box for who is designated as the legal custodian, whether it is the petitioner, the person who filed, the respondent, the other parent. If the parent with whom the children spend the majority of the time is not the same for all of the children, you may make separate legal custodian designations here. If you are designated the legal custodian, you may have to execute a form to allow the other parent to claim the children if they receive tax benefits and you do not. You should consult a tax advisor in this case. When the child's time with one parent ends and time with the other parent begins, the parenting plan should provide standard arrangements for transferring your child or children. You will propose those arrangements in this section. Part 1 is for weekday transfers, and Part 2 is for weekend transfers. These transfers may take place at the petitioner's residence, the respondent's residence, the child's school, or another location noted here. A couple of recommendations for locations. If you live apart, determine a midway point to meet. If your case has a history of domestic violence, choose a location that is public and has cameras such as a gas station or a police station. Decide what time the transfers will occur and note them here. This should be in line with the parenting time noted in prior sections of the parenting plan. If there are other arrangements, you would include those here. A couple of things to keep in mind when transferring. One transfer arrangement is the same in all parenting plans. The court notes the parent waiting for the children should always allow a 30-minute grace period. This is underlined to emphasize how much the court wants you to be patient and understanding. In this section, we talk about transportation arrangements for the children. Read through each section and decide which arrangement you would prefer for your transportation and special travel. Typically, people check the first box indicating every transportation shall be the responsibility of the parent with whom the child is with. For special travel, the cost is usually the responsibility of the parent who wants the special travel. Page 11 covers telephone contact between parents and children. The parent with whom the child is not with needs to make special efforts to stay in touch with the child, and the parent with whom the child is with should encourage the child to stay in touch with the other parent. Telephone contact includes video conferencing such as Skype, FaceTime, or Facebook Messenger. Here you will select when the child can call the parent, and here you'll select when the parent can call the child. The bottom portion of page 11 covers communication between parents. Parents need to regularly communicate with each other to provide the best possible care for their children and reduce the stress on your children. You are now going to propose the arrangements for how the child's other parent communicates. There are 5 requirements in all cases. We will review them, and you should check them as we go through them. The parents will inform each other as soon as possible about all of the children's school, sports, or other activity schedules to ensure nothing interferes with the children's participation. The parents will always let each other know their current residences, mailing addresses, home, work, and emergency telephone numbers, and will notify each other within 24 hours of any changes in these matters. This requirement does not apply in family law cases in which the family court has allowed the withholding of identifying information. The parents will never say anything in the children's presence that would reduce the children's love or affection for either parent. The parents will never allow any person in the children's presence to speak poorly of an absent parent. And the parents will never discuss disagreements or financial matters in the children's presence. Do your best to follow these requirements. These are things that make judges upset at parents and do not put the children's best interest first. Page 12 is a continuation regarding communication between the parents. A parent should not schedule activities for the children during the other parent's scheduled parenting time without the other parent agreeing in advance. You may list exceptions here, such as sporting events or other extracurricular activities that your child is involved in. This decision goes to being reasonable, practical, and reflecting what is in your child's best interest. Put yourself in the other parent's shoes. How would you feel if there were activities scheduled during your parenting time? Use the rest of this space to propose any other communication arrangements that you want as part of your parenting plan. As your children grow, their lives, activities, and schedules will change. In the short term, parents and children will have occasional, unavoidable changes in parenting arrangements. By agreeing ahead of time as to how these changes will be handled, you can avoid the time and expense of going back to family court. 3 rules should apply to all changes. If one parent requests a non-emergency change in the parenting arrangements, the parent receiving the request will decide whether to permit the change. If a change in parenting plan arrangement is required because of an emergency, the parent with custody of the children at the time of the emergency does not require advance agreement of the other parent to make the change, but must notify the other parent of the emergency as soon as possible. Do not use the children to communicate changes in the parenting arrangements. Now, select how you propose handling non-emergency changes in the parenting plan. You will need to check the first box to indicate you understand that a parent receiving a request will never use it as a bargaining chip or a way to punish the other parent. Changes in the parenting arrangement continue on page 13. This talks about how the parent will make the request, when the request will be made, such as 24 hours, and when the parent will respond. Page 13 is a continuation of page 12, and it talks about how the parent will respond to a request for change, in person, by phone, by writing, or by email. This section is designated for those who are in the military. If either parent is in the military, you should address what will happen if the parent is deployed. In this section, you will include additional terms and conditions. If you feel like something important was missed on the previous pages, list it below. Some example could be the other child's parent needs to complete anger management, or the child's other parent needs to be drug screened. If there are no additional terms or conditions, check the first box and move to page 14. Page 14 covers how to settle disagreements. Despite a good parenting plan and the best of intentions, parents may still have disagreements from time to time. These disagreements may be harmful to the children and to the parents' relationships. By agreeing in advance on a way to settle disagreements, you may avoid the time and expense of going back to family court. Some options would include counseling, and you could list the counselor here, mediation, and select the mediator here, or some other means. You may decide in advance how cost of settling a disagreement should be handled. You may also allow the person settling the disagreement to decide how costs would be shared. In this section, you'll decide how you should notify each other if you have a disagreement. The remainder of page 14 is important information that you should review. We have reached the last page in the parenting plan. On this page, you will sign whether you are the petitioner or the respondent. If you're submitting this plan jointly, you will both sign. This verification must be signed in front of a notary public, and the notary will notarize the document for submission to the family court. You have completed your parenting plan. If you require additional services, you may contact Legal Aid of West Virginia. We hope you found this presentation beneficial. A presentation of Legal Aid of West Virginia.